Last Friday, the Governorship Election Tribunal on the Osun State governorship election gave its verdict nullifying Governor Ademola Adeleke's victory and asking INEC to issue a certificate of return to former Governor Gboyega Oyetola of the APC, blaming it on overvoting and deducting some figures in about over 700 voting centers. Now, what this has brought to the fore is the issues relating to the role of BVAS, the role of INEC, and what really happened on the field. Considering the chances of the APC and the PDP, all this put together, the PDP had gone to the appeal court to file an interest to appeal the matter. But how will this all pan out? What is happening on the ground? What are the legal angles to all of this? What is the APC or the PDP? What are they saying about these issues? Let's get perspectives onto this one. I'm being joined by Mr. Hashim Abioye, who is a lawyer and on the team of the Senator Adeleke, the governor of Osun State side of the divide. He joins us virtually live from Osogbo. And from our Lagos studio is Mr. Oloruntomi Loba Olagunju, also a lawyer on the side of the former governor, Gboyega Oyetola. Thank you so much, gentlemen, for joining us tonight. Let me begin with Mr. Hashim Abioye, who joins us from Osogbo. A lot of commentaries that we have heard about this matter, Mr. Abioye, the fact that there was overvoting. In fact, we saw a statement from the governor today that he did not forge, because that was also part of the ruling, that there was some kind of forgery about the certificate. At the time that the governor got the certificate, there wasn't like anything like Osun State. What is the reaction coming from your side in the defense on this matter? On this matter. On this matter. On this matter. On this matter.
As far as degrees, as far as degrees, as far as degrees, there were no genuine documents. But as a matter of fact, the tribunal found as a fact that those two certificates, that's the degree certificate and the high school diploma from Penn Foster College in the US, are genuine documents, and the tribunal came to a conclusion that Senator Ademola Adeleke was qualified. But he said, as far as the document he attached to his form in 2018 was concerned, and that is the testimonial from the Muslim Grammar School, that that forgery has been established. But what made the chairman of the tribunal to make that conclusion was not founded in law, because there was a decision of the Court of Appeal which was cited before the tribunal, but the tribunal, as a matter of fact, decision, meanwhile, that decision is binding on the tribunal, being a court that is inferior to the Court of Appeal. And apart from that, the decision of the Court of Appeal, apart from being cited before the tribunal, the judgment was equally tendered before the tribunal, but the tribunal rejected the document in the evidence. The Evidence Act, the tribunal is bound to take the notice of all court proceedings, especially court of records, in this case, the Court of Appeal. So what we are saying in essence is that as far as the issue of forgery is concerned, Senator Ademola Adeleke has been cleared, because the document in issue had actually been adjudicated upon by the Court of Appeal in 2018, and Lord Paragim, then now GSC, gave a judgment that Senator Ademola Adeleke never forged, and that the inconsistency in the document had been explained away by the principal of the school, who came to testify that it was an error, and that did not mean that Senator Ademola Adeleke did not attend the Muslim Grammar School.
All right.
The fact that there is a change in the name of the school from the Muslim Grammar School to the Muslim High School does not mean that the Muslim High School is not the same as the Muslim Grammar School. So the issue of forgery has been settled by the Court of Appeal. the tribunal was indeed wrong to have reopened that case. Tribunal left jurisdiction to the issue of forgery.
Let me bring Mr. Olagunju into the conversation from our Lagos studio. Isn't there's, I mean, if you look at the explanation of Mr. Abioye, that has been settled according to him in court. Isn't it ambiguous for the tribunal to have ruled in that respect on the issue of certificate, which according to him, it has been settled?
Well, I do not agree that the matter has been settled in court. All the three learned justices that sat on the tribunal came to the conclusion, rightly in my view, that the governor forged some of the documents he presented to INEC. And Sheon, even you will not find it difficult to come to that conclusion. If somebody has a document that predates 1991, and that document is headed Osun State came into existence in 1991. So if anybody has a testimonial or any certificate that bears Osun State before 1991, it should not be difficult for anybody who is not a lawyer to come to the conclusion that that document must have been a forgery. Mr. Abioye said the Court of Appeal had settled the matter. I do not agree that that is the situation. A document was presented before the tribunal, which the tribunal rejected in evidence. So it is not possible for the tribunal to rely on a document that it has rejected in evidence. So it is not for Mr. Abioye to say the Court of Appeal had resolved the matter. My own understanding of what transpired was that there was a case between Senator Adeleke and some other people, and the holding of the court was that the allegations were not proved against him. That does not preclude any other person from proving that same allegation. If Mr. Abioye was stylishly referring to the doctrine of res judicata, it binds parties to the suit in which a decision was reached. In this case, there has not been any decision in any case involving Governor Etola and Governor Adeleke on the issue of his certificate. It was very easy for the tribunal to come to the conclusion, and this decision was unanimous, that if you have a document that predates 1991 that bears Osun State, that document could not have been genuine. So I'm happy that my learned friend, Mr. Ashim Abioye, concedes to the fact that there are inconsistencies in the certificate of Senator Adeleke. But honestly, it goes beyond that.
Mr. Olagunju,
yes, please, sure.
Gentlemen, let's look into some of the meat of the outcome of that tribunal's ruling and allow Mr. Abioye to come in here. There was an establishment of the issue of overvoting, and that's why the trial court had gone ahead to deduct votes from the over 700 polling units, and same applied and discovered at the end of the day that Senator Adeleke has lesser votes to former Governor Oyetola. How does this come to you? Because I know this is one of the things that you fought very hard. There were different reports on the BVAS. What really went wrong? Who is to be blamed in this scenario?
Thank you very much, Sean, for that question. Let me tell you straight away that there was no establishment of any overvoting. If there was indeed an establishment of overvoting, we wouldn't have taken our matter to the Court of Appeal. Let me tell you what happened. You know, after the election, the APC applied to INEC for BVAS reports. Please get it right, BVAS report. When they got that report, they used that to file an election petition. So just to cut the long story short, when they filed their petition, we saw that on the face of the document, there was prima facie overvoting in 1,500 polling units. We applied as well to INEC, and we got another report from the same server. Let me tell you straight away, the BVAS report they are relying upon is from the server, not from the BVAS machine itself. So now we got another one from the BVAS machine, from the server as well, which showed overvoting prima facie in 100 polling units or so. So as a result of that, the explanation that INEC gave was that transmitting the results from the BVAS machines themselves to the back-end server require internet. So, and that the BVAS machine did not require any internet to function as in to capture information on the day of the election for the purpose of accreditation. It only requires internet network to transmit the information already captured in the BVAS machine to the back-end server. So if you want to talk about any report at all, any establishment of overvoting at all, you recall to the BVAS machine itself. Now what we did was that we applied to the tribunal for an order of inspection, with the tribunal granted for us to inspect the BVAS machines themselves, which we did. And from the inspection, we were able to place before the tribunal the results of the inspection, which did not establish overvoting as alleged by the petitioners, except in just 6 polling units.
All right.
And
so, Mr. Abioye,
machines as well. I'm coming. We brought the BVAS machines as well. Not only that report of inspection, we bought the BVAS machines themselves, and the BVAS machines themselves, plus the result of inspection which we conducted, plus the electoral form, did not establish overvoting in any respect. So what they relied upon at the tribunal was the report from the server, back-end server, not the report from the BVAS machine itself. And by virtue of Section 137 of the Electoral Act 2022, it is only when the original of a document or its certified true copy establishes overvoting. So, which one is the original document in this circumstance? It is the BVAS machine itself.
All right. So, Ms. Abioye, so the question is
the report of inspection.
Yeah. So, what has your side established in this matter? What did you see that went wrong in this case, in the case of the BVAS, that you are dissatisfied about?
Seun, what I'm saying in essence is that server, if you want to establish overvoting, you can only establish overvoting on the basis of the physical material that were present at the polling unit.
That's on the
server
BVAS
was
machine
not at the
physically.
polling unit in declaring result. If you want to declare result of the election, it is on the basis of the BVAS machines itself, on the basis of the electoral form, and on the basis of the voters register. Those were the critical materials at the polling unit. After the counting of votes, the presiding officer will pick the accreditation figure on the BVAS machine, record it on the electoral form, then declare the result, the scores of the party, record it in the electoral form as well, and declare the result. It does not require sending it to the server at all before the result will be declared. It is only during collation that you transmit to the backend server, and it's for technological hitches or whatever. It will not land in the backend server at the appropriate time. So if there is any issue as to what came out from the backend server, you recourse to the primary source.
All right, let me bring in Mr. Olagunju into this on this matter of the BVAS. What is your own side of, because it does look to me that there are some discrepancy here. There are 3 different reports.
Well, Seun, I think the first thing to say is that technology was brought into the electoral system of Nigeria to defeat the rather esoteric argument that my learned friend has put forward. A little bit of analogy may help us here. If I go out of your premises now, Seun, and I go to an ATM and I withdraw money, the information that I've withdrawn money is stored somewhere. I can recall it at any time. So for somebody to say that, for me to prove, that will show on my statement of account, which is generated from the server of the bank that I use. If there's any dispute as to how much I withdrew from the bank, who actually made the withdrawals, these are information that can be called up. That is what BVAS, the system of BVAS, the entire ecosystem of the technology deployed by INEC, has been brought in to do. So what Mr. Ashim Abioye is trying to say, for instance, is that if there is a dispute to the amount collected, perhaps you will need to go and bring the entire machine, the ATM, to determine whether or not monies were actually collected. In my view, this same position that Mr. Ashim pushed now was what the tribunal described as running riot to their defense. What we did, what the APC did at the tribunal was to say every machine is linked to internet, whether immediately or after the election. It transmits the data on it to a back-end server from which INEC can retrieve it. INEC retrieved it and gave it to Governor Oyetola. It was on the basis of that retrieval and the data presented that the petition was filed. After the filing of and at the time the documents were handed over to Governor Oyetola, it was not described as an interim report. It was not described as inchoate. It was not described as unsynchronized. It was after the governor had filed his petition, after technology had detected the flaw in the election, that the very ingenious arguments of my friends started coming in. And the tribunal had no problem, because the tribunal had no problem in seeing through that chicanery. The tribunal knew from the documents presented before it which one to prefer. So all this issue of one is the secondary source, one is the primary source, these are the kind of arguments that the technology deployed by INEC came to defeat. INEC gave out a document. This is the number of voters accredited in these units. We can compare that with the Form C8A to know the number of people who voted. Once the number of voters exceed the number of voters accredited, overvoting will have been established. Therefore, the rather very, very grandiose argument, esoteric, is to complicate a matter that technology has been brought to simplify.
All right.
BVAS is the game changer.
Let me again go back to Mr. Abioye. Yeah, so let's look at it. You are going to the appeal court. The tribunal has asked that INEC should issue a certificate of return to former Governor Oyetola. What did you find wrong in the judgment of the tribunal which you are dissatisfied about?
Thank you very much, Sean. You must have read the judgment of the Lord Justice Ogbuli. That is the dissenting judgment. You will see that from that judgment, his lordship came to a conclusion that in the event that controversies have been established as per the report gotten from the same source, the server, not from the primary source. Our argument is that if you are talking about the primary source of the BVAS machine, it is the BVAS machine itself. If you are talking about the certified true copy of the BVAS machine, it is the report that we got on the order of inspection granted by the tribunal, the certified true copy. Both the machine and the reports gotten on the order of the tribunal did not establish overvoting except in 6 polling units. Take that. Now the report which they erected their case on was from the back-end server. We got another report too from the back-end server, and that brought about the controversy. When the controversy came, then the best evidence to be applied in the circumstance before the court is the primary evidence, the primary source, to recourse to the primary source. So I did some transaction on Saturday from my bank. So it was about this time yesterday that I got a lot of those transactions which I had done since Sunday. So that is technology for you. All right. And if you read the decision of the Supreme Court in Inyesom Wike and Peterside, you will see that this was the premise upon which the Supreme Court set aside the decision of the Court of Appeal and the trial tribunal. The Supreme Court was even ahead of this technology, because at the time that decision came, this technology, the smart card reader or BVAS machine or whatever, was in the manual then. It had not been
Mr. Abioye, let me
of the Electoral Act.
Yeah, I wanted you to establish. Yeah, I wanted you to establish your side's grievance about this matter, and let me go to Mr. Olagunju perhaps to wrap up now. I mean, the judgment read that it says that, and I want to quote, the second respondent can no longer go lololo and buga. And there's been a lot of criticism about that statement in that judgment, which is part of the controversies also that have been raised in this matter. On a final note, How do you see that kind of statement in that judgment? If you look at other judgments that had this similar kind of innuendos been criticized as bias, what do you make of that? And based on the controversy that Mr. Abioye raised, how do you think that the appeal court will see that?
Well, the appeal court will deal with the issues on appeal. The statement credited to the judge regarding the Buga phrase is what in law we call obiter dictum. It means statements that are just made in passing. They are not part of the judgment. Without holding forth for the judge, if you look through the entire judgment, you will see places where the judge cited Shakespeare. If you look at judgments generally, judges sometimes in driving home their point make statements in passing. They are not part of the judgment. They are not appealable. You cannot, for example, appeal the fact that you just said Buga, because that is not the reason for the decision of the court. In a judgment, there are actually two parts. There's what we call the ratio decidendi. That is the reason for the judgment. And if you read that judgment, you will see the reasoning of the learned justices that sat on that tribunal. They gave reasons why they came to their conclusion. The Buga thing is what we call obiter dictum. It was just a statement made in passing. It has nothing to do with the judgment. It is, in my view,
all right,
a way to calm nerves when you read judgment without actually holding forth for the chairman of the tribunal. So the fact that the judge said that does not mean bias.
All right.
Bias cannot be imputed out of that kind of statement. It is a statement made in passing,
those are some of the
which does not affect the judgment
being raised
at all.
on the judgment. Yeah. Well, thank you so much, gentlemen, for your input and perspective that you have given this matter tonight. Mr. Ashim Abioye, a lawyer on the team of Senator Ademola Adeleke of the PDP, and Mr. Tobiloba Olagunju, a lawyer on the side of the former Governor Boyega Oyetola. Thank you so much, gentlemen, for coming tonight.